Jose Chili de Castro, Sean Paul Long Island Audit Reyes, and Clash with Bow take to the streets to march with anti-ICE protesters. What did they have to say about the man in the street? And more importantly, how much money did they make from their live streams? Christopher Denver Metro Audits Cordova asks a judge to allow him to reinstate a recently dismissed claim against Jonathan Frauditor troll Huneault in their ongoing war. Will the judge allow him to refile once he gets his video copyrighted? Plus, Chili de Castro has doubts about his upcoming trial against the Las Vegas Metro Police Department. Will his recent fundraiser help quell his nerves? I'm your humble newsreader, Pence, and I welcome you to the first episode of Volume 2 of Auditing Insanity. A late Friday filing of a motion to dismiss counterclaims by that Randall S. the Unhinged Attorney Newman, Esquire, in the case of Christopher Denver Metro Audits Cordova versus Jonathan Frauditor troll Huneault, was completely overshadowed by a ruling late in the day by Judge Virginia K. DeMarchi on the merits of Huneault's own motion to dismiss. DeMarchi's ruling may have been more significantly helpful to Newman's counterclaims had he not filed a few days before his January 27 deadline. In her ruling, the judge had significant questions about Huneault's original fair use arguments before the later revision by Huneault that claimed that he believed that he had a perpetual non-exclusive license to use Cordova's material based on statements made in a newly discovered live stream in 2022. That claim by Huneault lies at the heart of both his counterclaim against Cordova and his response to Cordova's second amended complaint. In his counterclaim, Huneault asserted that Cordova was at fault in filing DMCA takedown notices that resulted in the temporary removal of Huneault's Frauditor troll channel in 2023. He alleged that Cordova's actions were in violation of the licensing agreement and willingly and maliciously inflicted damage to Huneault's channel and his working relationship with advertisers. Addressing the discovery and the revised take on Huneault's belief that he had a perpetual license, Newman noted, "Plaintiff alleges that defendants unlawfully reproduced, displayed, and monetized portions of his copyrighted videos and brought claims against defendants for copyright infringement, misrepresentation under Section 512F, circumvention of technological protection measures, and declaratory relief. Defendants deny liability and contend that their videos were authorized and or protected by fair use under 17 U.S. Code Section 107. Plaintiff submitted multiple DMCA takedown notices to YouTube in 2023, identifying videos uploaded by defendants that plaintiff contended infringed his copyrighted works. Defendants responded by submitting DMCA counter notifications pursuant to 17 U.S. Code Section 512G, asserting that the challenged videos were non-infringing and requesting reinstatement of the removed content. In those counter notifications, defendants asserted that their videos were protected by fair use. The counter notifications did not assert that defendants were authorized by plaintiff to use the copyrighted works, nor did they claim the existence of any express or implied license. In her own ruling on Huneault's motion to dismiss, again based on Huneault's first version of his defense, Judge DeMarchi noted that Huneault made a demand of $9,000 from Cordova in a letter following the takedown of his channel, and did not mention his belief that the material was licensed in her notation. Newman continues, defendant's license theory fails for an additional independent reason. Their own contemporaneous conduct is fundamentally inconsistent with any genuine belief that plaintiff had granted them authorization, express, implied, or otherwise, to use his copyrighted works. At every stage where a license or authorization would have been legally relevant, defendants failed to assert it. First, in their DMCA counter notifications submitted to YouTube pursuant to 17 U.S. Code Section 512G, defendants did not claim that they were authorized by plaintiff to use the copyrighted works. Instead, they asserted that the videos were non-infringing and protected by fair use. The counter-notification process is expressly designed to surface defenses to infringement, including authorization. Defendants' failure to invoke any license at that stage is telling. Second, in contemporaneous emails sent by Huneault to plaintiff on the very day the copyright strikes were issued, defendants again did not assert that plaintiff had granted permission or consent. Those communications focused on disagreement with plaintiff's infringement position, not on the existence of any license. If defendants genuinely believed they possessed ongoing authorization, one would expect that belief to have been asserted immediately, particularly when facing removal of content. Third, defendants did not assert authorization or license in the joint statement filed with this court, nor did they do so in their initial motions to dismiss plaintiff's claims. In both instances, defendants advanced fair use arguments, but conspicuously omitted any claim that plaintiff had granted them a non-exclusive oral license to copy and monetize his works. This pattern of omission matters. Under California law, contract formation turns on objective manifestations of assent. Defendants' silence when authorization would have been dispositive undermines any claim that the parties shared a contemporaneous understanding that a license existed. A purported license that surfaces only later, after litigation has commenced, and only in the form of recharacterized informal remarks, is not evidence of mutual assent. It is evidence of post hoc reconstruction and fabrication. Here, defendant's course of conduct confirms that their license theory is not a belief held at the time of the takedowns, but a litigation-driven reframing introduced only to increase plaintiffs' litigation costs, after realizing their fair use affirmative defense was legally weak. California law does not permit parties to manufacture contractual rights through hindsight, and the Declaratory Judgment Act does not authorize courts to ratify such after-the-fact theories. A hearing has been set for Newman's motion to dismiss the counterclaims on March 3rd. This is a continuing news story. Accusations of gratuitous crowdsourcing for unneeded donations resurfaced on Sunday against Sean Paul Long Island Audits Reyes, as he revealed secretly recorded audio of his recent encounter with Border Patrol officers in Texas that resulted in roughly $5,000 in new donations to his GoFundMe campaign. Reyes's audio, despite the secret source, was primarily a recycling of audio heard from videos that had previously been released by the king of all auditing. Despite being what Reyes would eventually describe as a Fifth Amendment audit, it showed that Reyes never invoked his Fifth Amendment rights, nor did he stay silent in the presence of officers. In those minutes of audio, Reyes was largely confrontational with agents, telling them essentially that he was famous and that he knew the law, as most of his best friends were lawyers. He boasted that they'd soon face repercussions for their actions if they didn't free him immediately. The dramatic packaging of the audio was accompanied by a pitch for Reyes's "Detained for My Rights, Continuing the Fight for Our Rights" fund. The YouTuber, despite facing no criminal charges at this time from the incident. In exchange for their donations, Reyes would only commit to a vague pledge to take every legal means necessary to hold the agents accountable for his alleged mistreatment. Critics immediately pounced on Reyes, who seemed more concerned about generating outrage to pull in new donations and merchandise sales than he was in actually performing his acts of retribution from the government. Those same critics remembered Reyes's actions from the summer of 2025, when he ignored private road signs to confront a now former Connecticut State Trooper at his home. This action resulted in a verbal confrontation with the man and an arrest of Reyes, even though the former officer spat in his face. Reyes turned that incident into over $55,000 in donations from his fans towards a legal defense GoFundMe. The charges against Reyes were later reduced to misdemeanor offenses, with the YouTuber facing little to no legal consequences for his actions, nor a need for his enormous intake of funding. Critics also remember an ill-timed family vacation that happened in the middle of the controversy surrounding the incident. The 2-week work vacation saw the YouTuber continue to pull in record donations, despite taking a break from his efforts to spend time with his family. Reyes's dramatic audio and pitch to his audience turned around a relatively unspectacular weekend for his campaigns. None of his campaigns pulled in donations for Saturday, January 24th. That day was dominated by the YouTuber known as the First Amendment Protection Agency, with $220 in new donations to his illegal arrest defense fund. Second place went to Frauditor Trolls Help Us Fight This Anti-Free Speech Retaliation Lawsuit campaign, which took in $68 for the day. Reyes's rebound started on Sunday, January 25th, as his Detained for My Rights, Continuing the Fight for Our Rights fund pulled in $50. Frauditor Trolls campaign placed second with $17 in new donations, which was followed by the First Amendment Protection Agency's campaign, which pulled in $10. Finally, after Reyes's surprise audio, his Detained for My Rights campaign pulled in $4,940 for Monday's take, followed by the First Amendment Protection Agency, which pulled in $135, and Frauditor Trolls campaign, which brought home $69. Nice. Reyes also ended his video with a pitch for his lucrative merchandise line. The YouTuber's financial windfall after he never invoked his Fifth Amendment right, never followed through on keeping silent, was never charged with anything, and would later threaten to protest at the homes of agents while taking every legal avenue possible to punish the agents, is more proof that the YouTuber is considered Teflon within the community. His estimated YouTube earnings of $50,000 to $100,000 per month indicate that he's not in need of the money he's requesting. It's icing on a lucrative cake that will replenish itself as long as his fans are willing to part with their money. This is a breaking news story. Tuesday saw a new filing in the case of Executive Lens LLC versus Rapkin, when that Randall S. the Unhinged Attorney Newman, Esquire, filed his response to defendant Lee Rapkin's motion to dismiss his first amended complaint. Newman is representing a limited liability company owned by Christopher Denver Metro Audits Cordova in a lawsuit against an attorney, Lee Rapkin, who filed DMCA counterclaims on behalf of a YouTuber literally known only as The Exposer. The Exposer's identity has been a weird side issue with the lawsuit. While the Exposer is named a defendant, his identity has never been established due to Rapkin's elevated defense of her client. Instead, the heart of the lawsuit, and at the heart of the motion to dismiss, are Rapkin's actions when she filed multiple DMCA counter-notices on behalf of the Exposer, substituting her own information in order to prevent the Exposer from legal consequences associated with improperly using Cordova's material. Cordova, through Newman, also asserts that Rapkin submitted the DMCA counter-notices without reviewing the videos and misrepresented the content of the videos in her sworn statement, and issued the same blanket counter-notice for all of the videos at issue. Newman wrote, "The first amended complaint does not allege that Rapkin merely misapplied the fair use doctrine or reached an incorrect legal conclusion. It alleges that she certified, under penalty of perjury, that 17 separate videos were, quote, significantly transformed by detailed editing and elaborate commentary throughout, unquote, when at least 8 of those videos contain no commentary of any kind. A video with zero narration cannot factually contain elaborate commentary throughout. That is not a legal judgment. It is a verifiable factual assertion, and plaintiff plausibly alleges it was false. Plaintiff further alleges that Rapkin submitted a single blanket counter notice covering 17 non-homogeneous videos without conducting a video-by-video review, certifying uniform, detailed, factual characteristics across disparate videos, some with commentary, some without, some consisting almost entirely of plaintiff's footage, supports a reasonable inference of knowing misrepresentation, or at minimum willful blindness. Under Ninth Circuit law, deliberate avoidance of review while making categorical factual certifications satisfies Section 512F's subjective scienter requirement. Plaintiff also alleges that Rapkin concealed the identity of the subscriber required to be disclosed under Section 512G3D, substituting her own information while continuing to withhold the channel operator's identity even after litigation commenced. That conduct is not pleaded as a standalone statutory violation, but as circumstantial evidence of intent. Taken together with the standardized factual misrepresentations and alleged lack of review, it supports the inference that the counter-notification was not submitted as part of a traditional, independent legal assessment, but as a strategic mechanism to shield an anonymous channel from platform enforcement consequences by exploiting YouTube's automated reinstatement machinery. Cordova, through Newman, was essentially forced to file suit against Rapkin because YouTube requires legal action to be taken to prevent the restoration of the videos that have received counter-notifications. They ask the court to reject Rapkin's motion to dismiss, as she knowingly and willingly counter-notices in bad faith and would allow others to use the same process in future suits to avoid legal consequences of their misuse of copyrighted material. Defendants' proposed rule would immunize the very conduct that caused those injuries, knowing misuse of the counter-notification process to impose immediate litigation costs, while nullifying Section 512F's express damages provision whenever a copyright owner complies with the statute. Nothing in 512F supports such a loophole, and this court should not adopt a construction that rewards abuse and punishes diligence. Defendant's reading would erase that remedy whenever the copyright owner does exactly what the statute forces him to do: file suit promptly. That cannot be correct. As Business Casual makes clear twice, and by two different judges, 512F applies where a counter notice is used as a coercive tool to force litigation, regardless of whether reinstatement ultimately occurs. Defendant's reinstatement-only theory is incompatible with the statutory text, the structure of Section 512, and the case law, rejecting exactly that argument. The inference is straightforward. An attorney acting in good faith to correct a genuine mistake has no rational reason to hide the identity of the very party who must stand behind the counter notice's statutory declarations, including consent to jurisdiction. But an actor seeking to exploit the DMCA process for channel preservation reasons does have such a reason. Anonymity reduces accountability, frustrates follow-up enforcement, and increases the costs and friction imposed on the copyright owner, who is forced into emergency litigation against a moving target. At this stage, plaintiff need not prove the ultimate reason for Rapkin's concealment of the exposer's identity. The question is whether the pleaded facts, taken together, plausibly support scienter. They do. The First Amendment complaint alleges 1. Objectively false, verifiable factual certifications applied across non-homogeneous videos. 2. Non-review or willful blindness. And 3. Purposeful non-disclosure of the subscriber's identity despite statutory text that requires disclosure. Those allegations jointly support a plausible inference that defendant's counter notice was not a good-faith correction of a mistake, but a knowing misuse of the counter notice mechanism. Dismissal would improperly resolve intent and credibility in defendant's favor, issues that are quintessentially factual and inappropriate on a Rule 12b-6 motion. Attorney Newman is seeking leave to amend the complaint on behalf of his client as an alternative should the judge find sufficient grounds to grant Rapkin's request to dismiss the lawsuit against her. The fan-proclaimed king of all auditing, Sean Paul Long Island Audit Reyes, returned to live streaming from Melbourne, Florida, Tuesday night, as he made new allegations about Melbourne Mayor Paul Alfrey. Reyes is currently suing Alfrey for defamation after Alfrey made vague comments about a YouTube personality whose actions resulted in threats against members of the Melbourne city government. The YouTuber originally was contacted by Mayor Alfrey's ex-sister-in-law, who made a number of accusations of financial misconduct against Alfrey involving the business that the mayor shared with his late brother. Reyes's original planned direct confrontation with the mayor at a Melbourne City Council meeting was disrupted, as it coincided with the planned debate over a renaming of a Melbourne city street in honor of slain right-wing personality Charlie Kirk. The mayor made his comments on his Mayor of Melbourne Facebook page following that meeting and Reyes's continued accusations against the mayor and city council members, resulting in Reyes's lawsuit. Since that time, Reyes has returned to Florida as needed, this time admitting that he was there in part as a vacation from the snow in Long Island, New York. The YouTuber was armed with what he called an anti-campaign ad, which he would later play in front of an assembled 6 to 10 people at the Melbourne City Council meeting Tuesday night. Mayor Alfrey was not in attendance. His latest accusations involved alleged misconduct by Alfrey when he served as a canine handler for the Melbourne Police Department before becoming mayor. Reyes claimed that he uncovered an incident where the mayor allegedly attacked a man while in custody. The YouTuber claimed that he has secret informants within the Melbourne Police Department who have verified the mayor's alleged wrongdoings as a police officer, but are afraid to publicly speak out. Fans of Reyes expressed relief that he seemed to turn his attention back to his efforts in Melbourne, following his recent focus on a border patrol stop in Texas earlier in the month, where he was briefly detained after refusing to identify at a checkpoint. They note that a man allegedly part of a smuggling cartel was recently killed at a Texas checkpoint, and that tensions are high in the area. Further confrontations, despite Reyes's statements that he is peacefully protesting, may prove dangerous to the YouTuber in the current negative political environment. Reyes's domination of the crowdfunding market continued at midweek, with his "Detained for My Rights, Continuing the Fight for Our Rights" campaign taking in $3,756 for Tuesday. His Support the Fight Against Tyranny and Corruption fund placed second with $180 in new donations. The First Amendment Protection Agency placed third with $65 in new donations, while Frauditor trolls Help Us Fight This Anti-Free Speech Retaliation Lawsuit lost $13 for the day. Wednesday continued Reyes's domination of the market with $741 in new donations to his Detained for My Rights, Continuing the Fight for Our Rights fund, taking in $741 in new donations. His Support the Fight Against Tyranny and Corruption fund took in $72 in new donations, while Frauditor Troll made $67 in new donations for the day. Reyes has announced that he will be holding a major live stream later today. Due to changes in the YouTube algorithm and seasonal slowdown impacting our subject matter, it's cold and auditors aren't leaving the house as much. We are currently facing a deficit with our normal monthly YouTube earnings. If you enjoy these reports and would like to see them continue, please consider making a donation via our GoFundMe in the description of this video to literally help keep the lights on, the cats fed, and these reports coming. Details are in the description below. For those who can't contribute, please like, share, subscribe, and comment. All interactions help with the algorithm and are greatly appreciated. Jose Chili de Castro made a late-night deadline to file his response to the Las Vegas Metro Police Department's motion in limine despite getting a one-day extension to the deadline, while his response to a motion to dismiss by defendants Agnes Botello and Clark County, Nevada, in another case, was filed in Pacer a month after he claimed to have filed it. Starting with the LVMPD case, De Castro had sought and was granted a single-day extension of the deadline to file his response to the motion in limine by the LVMPD in the lawsuit where he is suing the officers involved in his March 2023 arrest in Las Vegas. De Castro's response is important because the motion in limine was a request by the defense in the lawsuit to severely limit De Castro's ability to bring up certain subjects at trial. These include his acquittal of the charges spawned by the incident in state court and his ability to produce testimony as to the injuries he said he suffered during police custody. The LVMPD made a case in their motion that De Castro was presented with several deadlines to produce his evidence, but either ignored them or simply chose not to reply. The only evidence he presented of his injuries, for which he's asking $1 million in damages, was a single receipt from an urgent care facility after the incident. De Castro offered no affidavits from doctors about his injuries, no receipts, no proof other than his own verbal claims that he suffered permanent damage to his ulnar nerve or to his groin during the incident. In his filing, DeCastro's attorney, Michael Mee, dodges accountability for not establishing his injuries, providing evidence, or providing updated calculations for the damages he's seeking. Quote, "As to the claim that computations of damages have not been sufficiently provided, DeCastro specifically pled the damages he was seeking at the time of the complaint, as well as disclosed damages which are subject to mathematical calculation whenever they become available. Indeed, a table of damages is identified by the defendants in their motion as having previously been provided. In addition to the damages pled in plaintiff's complaint and set forth numerically, the nature of certain categories of damages being difficult to objectively quantify is not grounds to prevent proof of those damages at time of trial. Defendants have failed to demonstrate that they are entitled to relief." Unquote. Attorneys for the LVMPD are also seeking to stop any mention of the state trial and appeals hearing, where DeCastro was found guilty of the charges against him, served minimal time in county jail, then was acquitted upon appeal. The basis for the exclusion has been the ongoing issue of differences between probable cause at a state level and probable cause on a federal level. While DeCastro was ultimately acquitted on a state level, the laws in federal court differ, and the subject may cause confusion that would prejudice the jury. Mee states in response, "As it relates to the district court's findings and holdings, it is simply incorrect to reduce them to a mere finding that the prosecution failed to establish proof beyond a reasonable doubt at the justice court trial, and that the justice of the peace lacked the legal authority upon the evidentiary record to convict DeCastro. The order is not being offered for merely the inference that because the state failed to meet the beyond a reasonable doubt standard, probable cause is dispositively disproven. First, the district court did not couch its factual findings in terms of what the state failed to prove or disprove beyond a reasonable doubt, but rather made affirmative factual findings as follows. 1. After being ordered to cease speaking to the driver by Officer Bork, Mr. DeCastro complied. 2. Officer Bork claimed DeCastro did not back up, but the court found that DeCastro did back up when ordered to do so. 3. Officer Bork relied upon a 21-foot rule regarding the distance officers can be filed, and the court found that as a matter of fact and law, no such rule exists. None of these findings has anything to do with deference to the defendant and the state's failure to meet its burden of proof. To the contrary, they were affirmative factual findings without equivocation. Likewise, the court found that DeCastro's conduct was protected by the First Amendment to the U.S. Constitution. Again, this is not a finding that the state failed to prove that the conduct was not protected beyond a reasonable doubt, but rather was stated as an affirmative finding on a mixed question of fact and law. These findings do directly decide issues in this litigation which are identical to defenses the defendants are attempting to make in this case, and the weight of these findings is not diminished whatsoever by the fact that the trial requires proof beyond a reasonable doubt, as compared to probable cause. These findings by the district court are just as logically controlling on a probable cause analysis as they are on an ultimate finding of guilt. On his Tuesday night live stream, DeCastro seemed to hedge his bets on the lawsuit, stating, "Just so you guys know, there's a 95% chance I lose my federal case. Even though everything was on camera, I didn't break any laws. I was just invoking my right to press. I'm probably going to lose February 9th. Just remember that. When I go to trial, I'm probably going to lose. I know that. I sued to show you that you can't get justice in this country. The policies, procedures, and protocols have to be changed. I'm not going to get justice. We know that." DeCastro's Monday filing, released to Pacer on Tuesday, of his response to the motion to dismiss in the case of DeCastro v. Clark County, was also a surprise. Originally due on December 28th, the document itself is accompanied by a notice indicating that it served to Scott Davis, the Deputy District Attorney of Clark County, via the electronic filing system on December 30th. The accompanying documents all refer to the December 30 date. However, if electronically filed, they would have appeared in Pacer instantaneously on the 30th, and not the January 26th date indicated in the documents. The charges against Deputy District Attorney Agnes Botello revolve around DeCastro attempting to hold Botello responsible for her decision to change her recommendation for sentencing between pretrial and the sentencing phase of the trial for the March 2023 charges. Botello argued that she had total immunity for actions done as part of her role as a deputy district attorney. This would include immunity from lawsuits in her personal capacity, which is the basis for DeCastro's claims against her. In his reply, DeCastro argued that it was too soon to dismiss Botello from the lawsuit, as, quote, "she remains necessary for the limited discovery on Clark County's policies and customs." He also states that Clark County, Nevada must remain a defendant in its personal capacity, despite the argument made by attorneys for the county that, as a non-human entity, it has no ability to be sued in personal capacity. DeCastro argued that discovery is required before dismissal to the extent that Clark County is liable for unconstitutional policies or customs related to the case. While originally seeking over $60 million in damages in the lawsuit, DeCastro's amended complaint reduced the damages to be determined at trial. This is a breaking news story. YouTuber, activist, and fan-proclaimed king of all First Amendment auditors, Sean Paul, Long Island Audit Reyes, released an extended statement on his YouTube community about the death of protester Alex Pretti, following his visit to a memorial for Pretti in downtown Minneapolis, Minnesota on Wednesday. Reyes wrote, "I've been asked about my updated thoughts now that newly released footage from January 13th shows Alex Pretti in a heated confrontation with immigration agents. In the video, he is seen yelling, spitting in their direction, and kicking a vehicle taillight until it breaks. Agents then bring him to the ground, and during the struggle his concealed firearm becomes visible. For reasons still unexplained, the agents leave the scene without arresting him or even removing the firearm. which in my mind raises serious concerns and questions regarding the training of immigration agents. The footage shows Alex making poor criminal decisions that day. That should have been handled through the legal system like any other crime. Arrest, charges, court, due process. That is how accountability works in our country. What it does not do is justify what happened later. Nothing in that earlier incident changes the fact that Alex Pretti was killed by government agents after being disarmed. Nothing erases the reality that he was entitled to due process. Nothing makes street-level, unilateral government use of lethal force an acceptable substitute for a courtroom, a defense attorney, and a jury. We are a nation of laws. Guilt is decided in court, not on asphalt. It is also deeply disturbing that the public was told Alex was a would-be assassin and domestic terrorist looking to massacre law enforcement. Those are lies meant to gaslight the American people. That should concern everyone, no matter your politics. You can believe he acted wrong on January 13, and you can still believe his killing was unjustified. Those two things can exist at the same time. Accountability for citizens and accountability for government must go hand in hand, or freedom collapses. This is not about left versus right. It is not about party, agency, or ideology. It is about whether we still believe in the Constitution, due process, and the rule of law. We need to stand united as Americans who believe that no one is above the law and no one is beneath its protection. Reyes livestreamed for around an hour earlier in the afternoon from the memorial site and faced a mix of praise and criticism from his fans during the event, drawing a record low crowd of 2,241 at peak. The low turnout seemed to spook the YouTuber, who lashed out during the event when one of his longtime followers said they were unsubscribing from his channel. He singled out the subscriber and promised that for every 300 subscribers he lost, he'd gain 3,000, as his movement could not be stopped. As to what Reyes was actually doing at the site, it's unclear. He offered no real condolences to Pretti's family and only provided a wishy-washy conversation on Pretti's death, offering no real condemnations or praise of either side. To casual observers, Reyes essentially was standing around arguing with his fans over why he was ambivalent to the scene, as he did not support the police but didn't hate them either, adding that he recently taught First Amendment-related courses to 2 police forces. Reyes promised throughout the broadcast that he would attempt to gain access to the ICE detention center in Minneapolis at some time in the near future. As of press time, he has yet to go live from that facility. The reluctance by Reyes to take a side may have substantially hurt his fundraising ability for Wednesday, as donations were down to his multiple GoFundMe campaigns. The YouTuber known as First Amendment Protection Agency won the day, with $829 in new donations to his Illegal Arrest Defense Fund campaign. Reyes took second place with $400 in donations to his Detained for My Rights, Continuing the Fight for Our Rights campaign. Our own ongoing expenses fund took in $300 in new donations to take third place. Reyes's Support the Fight Against Tyranny and Corruption campaign placed fourth for the day with a $120 donation. Finally, Frauditor Trolls Help Us Fight This Anti-Free Speech Retaliation Lawsuit campaign placed fifth with $16 in new donations. We will continue to monitor Reyes's activities in Minnesota. The ongoing war between Christopher Denver Metro Audits Cordova and Jonathan Frauditor Troll Huneault continued on Friday, with a new filing that saw Cordova request the ability to refile a recently dismissed count in the lawsuit. One of the rare successes for Huneault in the lawsuit so far came in late January when Judge Virginia K. DeMarchi dismissed Cordova's request for a declaration that the use of his courthouse fail video by Huneault did not qualify as fair use under 17 U.S. Code Section 107. The judge ruled that Cordova needed a registered copyright for the video in order to seek declaratory judgment and attorney's fees. While Cordova is in the process of registering the video, its inclusion in this count before registration prevented the count from standing. Late in the week, that Randall S., the unhinged attorney Newman, Esquire, filed a motion requesting a hearing where he will move to change the current case management order to change the deadline to amend pleadings in the case. Newman is seeking to be able to amend his complaint in the case after the U.S. Copyright Office issues a copyright registration for the courthouse fail video. The attorney explained that while the video was submitted for registration on October 15, 2025, the issuance of the registration has apparently been delayed due to a backlog at the Copyright Office. The attorney listed the following grounds for his request. 1. Plaintiff acted diligently by filing the copyright registration application well in advance of the amendment deadline set by the court. 2. The Copyright Office has not yet issued the registration despite plaintiff's timely application. 3. The delay is attributable to administrative backlog, not any diligence by the plaintiff. 4. The requested amendment is narrow, non-prejudicial, and limited to conforming the pleadings to an issued registration for a work already central to the case. And 5. Defendants will suffer no prejudice from a modest extension tied to issuance of the registration. If granted, Newman is seeking, on behalf of Cordova, the ability to reinstate the claim that was dismissed last month, once the U.S. Copyright Office grants the copyright request. While the request may be processed at any time, Newman is asking the court for leeway in filing his motion to revive the claim. No opposition has been filed yet to the motion by superstar Steve Vondran, who is representing Huneault in the lawsuit. Attorney Newman also made news this week when he was allowed to appear pro hoc vice in Florida in the case of Helping Hands for Dignity Coalition versus Anthony Gurka, and an initial scheduling conference was scheduled for February 12th. Newman represents sometimes homeless activist and free-range grandmother Regan Benson, who owns the coalition. Defendant Gurka is being represented by attorney superstar Steve Vondran. The case was recently moved to Florida after attorney Vondran challenged the jurisdiction of a California court, where the case involved a plaintiff in Colorado and a defendant in Florida. Attorney Newman requested that the case be transferred to the Northern District of Florida instead of having it dismissed and refiled in the state. The case was moved in January, with both men needing to file to appear pro hoc vice, and neither are licensed to practice law in the state of Florida. Superstar Steve Vondran now has a February 3rd deadline to be admitted pro hoc vice and continue to serve on the case. Prominent YouTubers clash with Bao, Jose Chili de Castro, and Sean Paul Long Island Audit Reyes live-streamed from anti-ICE protests across the country on Friday, to the similar degrees of criticism as fans noted that the YouTubers saw no controversy at the protests. Starting with Clash with Bao, the currently Texas-based YouTuber said he drove for 2 days from Texas to make it to the ongoing anti-ICE demonstrations in Minneapolis, Minnesota, and was not at all prepared for the extreme cold of a Minnesota winter. While keeping moving with the crowd, Bao would complain about the cold and would ultimately need to take donations from his followers to buy proper footwear and more layers of clothing to protect him from the cold. Unlike the other YouTubers, Bao's coverage drew a scant 90 people as he casually wandered through the protests in downtown Minneapolis on Friday, taking a more humorous approach to his surroundings. His chant of "Don't let the immigrants fester" drew puzzled looks from some observers, who would stop and question what exactly he was saying with his chant. Bao made fun of himself and his own coverage, asking where the single women were as Friday's official march ended. More serious was the presentation of Sean Paul Long Island Audit Reyes, who also live-streamed from downtown Minneapolis. Reyes was actually marching with protesters while not officially participating in the march. The king of all First Amendment YouTubers spent most of his 2 hours walking with the crowd, with his eyes mainly on his chat, where he engaged with those trolling him on both sides of the issue. The YouTuber seemed disinterested in the events around him and seemed to be there to negatively engage with his chat, though every so often he'd stop to ask those around him if they were being paid to be there. In one instance, a woman answered that she was indeed being paid. She said she came from California and her boss was paying her for her time off as she went to the protest. Reyes briefly marveled at her statement before going back to negatively engaging with his chat. Reyes's message during the march was that his haters were unneeded, and that while he may lose some subscribers in the end, those with negative views of him or his presence at the march were unnecessary, and his channel would flourish without them. He repeatedly told his fans that his chat was not an airport. There was no need to announce their departure through unsubscribing. They could go without saying a word. Once his activities in downtown Minneapolis concluded, Reyes would again live-stream Friday night, this time from an ICE detention center in Minneapolis. Reyes spent about 40 minutes outside the Bishop Henry Whipple Federal Building Friday night. The building itself was heavily fortified with a series of gates and fences, keeping the protesters away from the building. The YouTuber spent his entire stream in the outermost section of the fencing, where protesters had set up a table offering grilled cheese sandwiches and hand warmers. Reyes returned to negatively engaging with his chat, this time chastising those who thought that billionaires care for anyone other than themselves, and calling out what he said were bots who had invaded his chat in order to troll the king of auditing. Putting his opinions on the line, the YouTuber told his chat that he didn't care who was being deported, as long as the deportations followed the rules set out in the Constitution. He continued to refuse to take a side while lashing out at both sides of the issue. Reyes would cut short his broadcast at the federal building after 40 minutes due to extreme cold. Finally, Jose Chili de Castro went live multiple times Friday night from the relatively pleasant confines of Los Angeles. The diminutive YouTuber said that he had seen coverage of riots in downtown LA that evening and had left his home to see if the reports were true. DeCastro returned to the same area where he had a confrontation with a group of teenage girls on Martin Luther King Day, claiming it was the epicenter of the protests in the city. When he approached the spot where he was assaulted by two men, and not mentioning the teenage girls, he stayed on the far side of the road and walked past the spot quickly. The YouTuber complained that he had been streaming in horizontal format on his main channel and in vertical format on his DLC Clips channel, yet YouTube was only promoting the vertical stream as the numbers of viewers between the channels greatly favored the vertical stream. Ultimately, DeCastro would stop his horizontal stream on his main channel and restart it in vertical, ending the only real drama for the night. Casual observers wondered about DeCastro's choice of outfits for the night. He faced the January heat of LA in a heavy black sweatshirt with press written in yellow block lettering, along with a gray bicycle helmet in an apparent attempt to emulate traditional war reporters. The unsightly combination made DeCastro stand out from the crowd, though DeCastro would eventually overheat from his insistence on doing wind sprints between locations and would have to take off his press gear. Unironically, DeCastro would spend several minutes complaining about YouTuber Matt Morrissey, who DeCastro said was restreaming video of the riots and taking in hundreds of dollars in super chats without sharing links to the original coverage. He also spent a good deal of time claiming that when he was governor, he would solve the homeless crisis by making it illegal to camp out on the streets of LA. Instead, DeCastro would assign tiny homes to each homeless individual to keep them off the streets. The YouTuber offered no plans on how he'd fund his project, but would later add that he would also increase the size of garbage cans in the city, as he complained that every garbage can along the march route was overflowing with garbage. Once his marching finished, DeCastro would return to his studio and later hold another live stream with the YouTuber known as Travel Jack. DeCastro is in the process of renaming Travel Jack to the Fifth Amendment Auditor. Jack's plans to go through another DUI checkpoint on camera while invoking his Fifth Amendment rights were apparently thwarted by a lost internet connection. DeCastro ended his live stream and brought the night to an end soon after that. DeCastro was expected to go live later on Saturday. A dejected Jose Chili DeCastro seemed to admit defeat at the end of his Saturday afternoon live stream when he raised $89 of the $5,000 he said that he needed in a GoFundMe he had started earlier in the day. The sometime civil rights activist and former executive explained that he needed $5,000 nearly immediately to bring in a witness preparation expert from Texas to prepare himself and his attorney, Michael Mee, for his trial scheduled for February 9th. DeCastro is suing the Las Vegas Metropolitan Police Department over a March 2023 incident where he was found guilty in state-level court of obstructing an officer and interfering in a crime scene. The diminutive YouTuber spent a short amount of time in jail before having his conviction overturned later that summer. DeCastro has claimed that he has experienced a brain fog since his time in jail, which has hampered his ability to focus on projects until Thanksgiving of 2024. He is seeking $1 million in pain and suffering-related damages. Strangely, DeCastro admitted on his live stream that he went to a doctor who confirmed that there was no permanent damage to his ulnar nerve. Among the scant information DeCastro presented in the lawsuit was an estimate for ulnar surgery to repair his permanently damaged nerve. It is unclear why DeCastro would need an expert to prepare witnesses for the trial, since DeCastro has yet to list any witnesses he is set to present at trial. The jury trial at this time will consist of DeCastro and the police involved testifying in front of the jury. DeCastro had made only $89 at the end of his live stream, which went a little over an hour on Saturday, with DeCastro seemingly dejected by the fact that most of his fans have been trained to donate to him via his Cash App, Venmo, and PayPal accounts, and that he brought in an undisclosed amount of money to those accounts during the stream. The former Power Rangers actor said that he was disappointed with the tally and said that he should never have opened the GoFundMe on his own and should have had someone else run the campaign for him, bitterly saying that he's raised thousands of dollars for others, but could not raise money for his own needs. DeCastro would go on to say that he believed that he would lose his current case against the LVMPD at trial, but was prepared to file an appeal. The YouTuber seemed ill-prepared for his current lawsuit, making notes as he watched body cam footage of the 2023 arrest of things he needed to have included at trial. One bright spot for DeCastro came when longtime supporter Chevy reportedly donated $400 to his PayPal early in the stream, which DeCastro said he would be applying towards suing Las Vegas police for a February 14, 2024 arrest. In that arrest, DeCastro was apprehended after crossing under police tape twice at a fatal incident scene in Las Vegas. While he was initially charged with obstruction, those charges would be dropped in the spring of 2024, while DeCastro was incarcerated after being found guilty of the 2023 charges. DeCastro's GoFundMe was created too late to be included in our monthly totals for January. However, we will list his tally in with the Sunday results later on in this report. Sean Paul Long Island Audit Reyes took Friday with $295 in donations to his Detained for My Rights, Continuing the Fight for Our Rights fund, followed closely by his Support the Fight Against Tyranny and Corruption fund, which took in $100. The First Amendment Protection Agency's Illegal Arrest Defense Fund took in $10 for third place, while Frauditor Trolls Help Us Fight This Anti-Free Speech Retaliation Lawsuit campaign lost $1 for the day and fourth place. Saturday brought in $125 in new donations to Reyes's Detained for My Rights fund, followed by the First Amendment Protection Agency, which took in $35, and Frauditor Trolls campaign, which lost $37 for the day. Final totals for January saw Reyes win the month with $17,774 in new donations, with $16,107 going to his Detained for My Rights fund, $1,107 going to his Tyranny and Corruption campaign, and $560 going to his Help Me Fight These Unlawful Charges and Injustice fund. The First Amendment Protection Agency placed second with a $5,294 take for the month. Frauditor Troll, despite recent losses due to conversion rate changes, came in fourth for the month with a $1,120 take. Our own ongoing expenses account placed fourth with $781 in new donations for the month. Press with Rankers revived GoFundMe brought in $70, and DeCastro's own Stand with Heather Chandler for Justice Fund brought in $10 to round out the performers for January. For the first day of February, DeCastro's Stand with Chile, DeleteLawz Federal Trial February 9th, 2026 campaign would take the day with $299 in new donations. Our own ongoing expenses campaign would place second with $200 in new donations. It was followed by the First Amendment Protection Agency, which took in $100 in donations for the day. Sean Paul Reyes's Tyranny and Corruption campaign took fourth place with $50 in donations, and his Detained for My Rights campaign placed fifth with $22 in donations. No other campaigns that we follow saw donations for Sunday. The Auditing Insanity podcast is funded in part by viewers just like you. If you enjoy our efforts and would like to see our podcast continue, please feel free to contribute via the GoFundMe or PayPal links in the description of this video. All funds go towards keeping the lights on, feeding ourselves and our animals, paying rent, and, of course, producing more podcasts. Our news stories are written by James Finch and are read by Pants, both humans. The art in our news stories is produced by James Finch using RealIllusion's iClone and character creator programs. Any animations accompanying the stories are produced in iClone. Our use of AI is limited to the occasional clip art provided by Adobe Express and help with our descriptions as provided by the vidIQ service. The Auditing Insanity podcast is copyright 2026 James Finch, and we ask that you ask for permission before using our videos or audio footage.